our last morning panel is SEC Crypto Enforcement and Regulation, State of Play. We have Jerome Tomas, partner at Baker McKenzie in Chicago, who will be moderating. He previously served as a member of the SEC's Division of Enforcement's Cyberforce. Is that the jacket?
Yeah, sure.
I wondered. We have Katherine Kirkpatrick Boss, who's General Counsel, Starkware, the developer of a cryptographic zero-knowledge proof system that seeks to improve the sociability in blockchains. David Hirsch, one of my former colleagues from the SEC's Fort Worth regional office before he went on to do bigger and better things as counsel to Commissioner Carolyn Crenshaw and be chief of the Crypto Asset and Cyber Unit in the Division of Enforcement. He's now a partner at McGuireWoods in DC. We have Renato Mariotti, who's a partner at Paul Hastings in Chicago. He previously served as an AUSA for 9 years in the Securities and Commodities Fraud section in the U.S. Attorney's Office. And we have Robert Musiala Jr., partner at BakerHostetler in Chicago, working in the blockchain and digital assets market since 2012, leading multiple digital asset investigations.
Well, thank you very much. So we're going to talk about cryptocurrency enforcement and regulatory trends, where we have been, where we are now, and where we're going. And I guess, David, maybe I'll start with you on this. So, I mean, for my money, if you had asked me last year at the same panel if we would be on this panel today with the same agenda from an enforcement standpoint in crypto, I would have said, what are you talking about? But there you go, shows how much I know. So maybe tell us about where we were a year ago and sort of where we are now, and then we can go down to, you know, Renato and Robert, and then come back to Katherine.
Perfect. So yeah, I agree with that. I also would not have predicted where we are today. It's been a literal 180-degree sea change in terms of the way specifically the SEC has approached crypto assets and crypto assets enforcement. In September of 2024, there were still a very large number of active litigations against some of the most well-funded and prominent crypto intermediaries in the world, lots of exchanges, some market makers, other key players within the crypto industry, all battling with the SEC regarding questions as to whether or not they should have registered, could have registered under the existing 33 and 34 Act expectations. I've been through multiple transitions while I was at the SEC of administrations. This is the first time that I can recall that not only have priorities changed significantly, but they also went through and dismissed active litigation that was pending in front of district court judges and in one case circuit court to try and get those cases back outside of the court's purview and give the SEC some room to think about how it is that the SEC should be approaching crypto going forward, and to be able to craft their own regulations, to be able to give Congress room to do some legislation on this, rather than having piecemeal decisions being arrived at varying paces at courts around the country. So, huge change.
So, Renato, maybe take it from there. So, you know, there's been a lot of talk about, you know, crypto enforcement is dead, and dead is my word, although I'm sure other people have used that as well. Would be curious to hear your views on that. I've got my own views on it, but curious to hear what you think.
So crypto enforcement isn't dead, but I would say right now it's largely moribund at the federal level. And I think, you know, that is in part a reaction to what we saw in the prior administration. You know, you mentioned the change and how extreme that change has been. I think I personally view the strategy that the last administration had in terms of enforcement in the crypto space to be quite radical. It was enforcement matters regarding registration without really providing a true path to register and real kind of not engaging with the industry regarding those efforts on their part to try to register. So I do think that approach should be in the dustbin of history. But you know, one thing that I will say is that it appears to me that there's very few active, if any, active crypto enforcement matters nationwide. Now, we saw the Tornado Cash prosecution that was by the DOJ, for example. There are things that are somewhat crypto adjacent that are going on, but I have not seen anything. There is, though, active state enforcement, very active state enforcement, which I'm sure we'll talk about later, and of course, private causes of action are rampant as well.
So let's talk about enforcement for a little bit longer, because that sort of is the theme here today. Is there a meaningful distinction that you draw, and maybe Robert, I'll point to you and then back to Katherine, between some of the, what I would say, more aggressive theories, whether it's, the sort of application of an Orange Grove Howey test to cryptocurrency and then saying, well, it's a security, therefore it had to be registered under Section 5. And then by analogy, sort of, the unregistered dealer cases that, of course, sprung from the security Howey analysis. Do we draw a distinction between those types of cases and sort of the more garden variety fraud, I use garden variety in quotes, that, touches crypto, but at the end of the day is really no different than fraud has been for centuries?
I would absolutely draw a distinction there in terms of what we've seen this year. And to underscore a little bit of the dramatic shift that David and Renato talked about, just to give an idea, at the beginning of this year, just about every major crypto company in the United States was either in active litigation with the SEC or being investigated. And within the first couple months of the year, all those actions were dismissed or dropped. And that gave, I think, a degree of comfort to the market when, for example, the market sees actions against crypto exchanges being dropped. Now, if you're operating crypto exchange, you've got some more comfort there. You see an action against a crypto trading firm being dropped or a crypto wallet provider being dropped. Now those types of business models had some additional comfort. And then simultaneously, we had the SEC over the first couple months of the year, almost on a monthly basis, issuing statements giving the market comfort that certain specific types of crypto-based activities would not be considered offers and sales of securities. So, and we can get into this, but things like meme coins, stable coins, proof of work mining, proof of stake mining, all of these activities that are kind of fundamental to the market. The SEC issued statements on many of those alongside these dismissals. And at the same time, we did have a couple enforcement actions related to garden variety fraud, large-scale frauds in the crypto space, and so those have also continued. And so again, to answer your question, Jerome, I do think that there's a divide there.
So, Katherine, I want to get to the sort of the ultimate question here, the 10,000-pound gorilla in the room, which is, I remember back, I think it was 2017, when SEC Chair Clayton, I think it was like working out at lunch or something, and he was being interviewed on CNBC. And he was being interviewed about crypto, and they asked him point blank, what is the SEC's view on whether cryptocurrencies are subject to SEC regulation? And Jay Clayton literally gave the Howey test. He said, if a cryptocurrency or a token, and then he recited the Howey test, falls within that definition, our view is that it is a security. And I remember my immediate reaction was, A, well, he seems like he's a knowledgeable securities lawyer, but B, that made sense to me, at least as an SEC lawyer. 8 years later, 9 years later, I think the fair question is, Howey is still the test. There's still the law of the land, but is it the right test? Is it the test that will remain for purposes of determining whether and who has jurisdiction over cryptocurrencies? So I sort of throw that to you.
Yeah, it's a great question, and I was laughing because, so I remember vividly being on this panel 2 years ago and actually being quite terrified to be on the panel. In all seriousness, that was the environment about how you felt as a market participant in crypto. I was very reticent about even appearing on the panel for the fear of my company popping up on the radar of the SEC. So it unfortunately created an environment where crypto felt, and this is open to interpretation, very unfairly persecuted. And not just by the commission, also by banking regulators. We've heard a lot of that narrative from the Trump administration, undoing things like choke point 2.0, et cetera. We're in a dramatically different environment. I think specifically to answer your question, a lot of that depends on legislation. So in the EU, they passed comprehensive crypto market structure legislation, MiCA for short, that came into full force in January. It's a very flexible test, and it does create a token taxonomy, effectively. The Clarity Act, which is an important piece of legislation, crypto market structure legislation, which passed in the House with an overwhelmingly bipartisan majority. The Senate has a materially different version and likely less support from the Democrats, so it's very unclear whether that will actually be passed. Also contemplates what is effectively a token taxonomy. You know, what is a commodity, what is a security? And it's not always reliant on Howey.
Can I stop you there?
Yep.
Because I want to aim for this to be a New York Times
Yep.
version of cryptocurrency enforcement. So there are two things that you said
Yep.
that I wrote down that I want to make sure everyone understands. One, which is undoing choke point 2.0.
Yes.
Como se dice en inglés?
So one of the things that I think people need to understand about the broader enforcement environment, although recognizing that this is an SEC enforcement conference, is that it wasn't just the SEC that was going after crypto. It was pretty much all of the federal regulators, including the banking regulators. So a multitude of crypto companies and individuals tied to crypto were debanked effectively. And the Trump administration has really issued a top-down mandate to all of the federal regulators, including the SEC, undo that, reverse that, and create an environment for crypto in the United States where it can thrive. Because Trump is taking the position that the United States needs and wants crypto to thrive because it will ultimately bring jobs and revenue and economic benefit to the United States, which is something that the crypto industry has been saying for years. I'll also just add, I think Robert's absolutely right. Crypto and crypto market participants and GCs in the space have never disputed or never had any issue whatsoever with the SEC pursuing garden variety fraud. If anything, I really want to encourage federal regulators and the SEC to go after those projects that are clearly violating the law, doing inappropriate things, not in the gray, but black and white. Crypto had an issue with registration issues, those enforcement actions which were far more gray and are still gray to this day.
I'm going to open it up to the other panelists in a second, but I want to unfairly target you for one more question, which is you said token taxonomy.
Yes.
Can you maybe elaborate what you mean by that?
Well, right now we're still in this very confusing state of play, and my company has a token, so obviously I'm hyper conscious of this. But what is each crypto asset? Is it a security? Is it a commodity? Is it a collectible, as the SEC articulated in the meme coin guidance? And where is the line? Like, is the Howey test the test for that token, or is it something else set forth in legislation? And frankly, what are the parameters of the Howey test? Because the issue with Howey has always been the benefit is that it's flexible, but the negative is that it's flexible. So the interpretation of Howey under the Chair Gensler's administration was quite different than the interpretation of Howey from your average market participant. And one other note, I want to note that I think this is important. A lot of people refer to crypto as cryptocurrency. I actually want to make an important distinction here. I refer to crypto as the broader industry or ecosystem, because the reason for that is all of what you see in crypto or blockchain is based on cryptography, which is an underlying math-based science that effectively uses advanced technology to encrypt data. So what we're talking about, a lot of what the SEC and SEC enforcement has gotten involved in pertains to crypto assets, but it's so much more, and the industry is so much more, and the industry suffered, collateral damage from the enforcement environment in the previous administration.
Okay, you just sent me an ESP to go right to Robert on the question, because Howey is flexible, that's the good and the bad side. So do we expect the SEC to issue any guidance on this, and what do we think that guidance will look like? And then we can come back this way.
So from the SEC's perspective and sort of looking at recent statements by SEC Chair Atkins, I do believe we will get proposed rules sometime within the immediate to short term. And it'll be interesting to see what form those proposed rules take, especially because Chair Atkins has made statements in various speeches disagreeing with some of the approaches that have been taken in the past, in particular this concept of decentralization. So in applying the Howey test, the industry, I think, over the last several years has been hyper-focused on the concept of whether or not a network that a crypto asset resides on is quote-unquote decentralized. And this term decentralization has technical meaning, but it has also kind of taken on legal meaning within the constructs of the Howey test. Chair Atkins has recently given two speeches, one in which he said that the days of decentralization theater are over, another in which he said that decentralization is a red herring, and where he explicitly disagreed with a 2018 speech by an SEC director, which was the first speech that used that term decentralization. And so what all that means, in my view, is most likely we will see proposed rules by the SEC for how to distribute crypto assets in a way that complies with the securities laws, and most likely that whatever framework those rules take will not rely on this concept of decentralization. And that gets even more interesting because that very concept of decentralization is very much a part of some of the pending legislation that's currently before Congress, so we can talk more about that.
Yeah. So, yeah, I guess my take is that we really have a fork. We have two paths we can go down here. One is, and Katherine mentioned this, clarity. So if we end up having legislation that's passed, I'm told we're on track for January, we'll see, it's all up in the air at this point, then I think we're in a totally different world where digital commodity is defined very broadly under the Clarity Act. We may be securities and commodities enforcement essential next year if we're talking more about digital assets, because there's a lot of things that we think of in this space, or tokens that come to mind, would be considered commodities. And by the way, Chair Atkins has mentioned that he thinks most the vast majority, I think he said, of digital assets are commodities. But obviously, counting on Congress to come together to do anything is always a dicey proposition. And so it's very possible we're going to be in a world of rulemaking. Either way, though, if we have new legislation that will modify the Howey test, we'll suddenly have legislation that we're going to be dealing with. And on the other fork, if we have rulemaking and we're end up just in rulemaking land, either way, I'm thinking we're going to have years and years to go before we have true clarity, pun intended, regarding how to classify specific assets as securities or commodities. And that's because rulemaking is very slow, and these agencies, namely the SEC and CFTC, although they're working together supposedly now, hand in glove, have not always done so.
Well, yeah. So you go.
So yeah, I was just going to jump in there. So that's true. SEC and CFTC have not always worked hand in glove, particularly on the topic of crypto. But just kind of zooming back for those of you who aren't deeply steeped in the lore of crypto over the last 8 years. In the US, regulating crypto has been particularly challenging because of this dichotomy we have, where we have one agency that regulates securities and a different full regime that regulates commodities. And they've got different risks that they're trying to control for and different market participants that they are used to dealing with. And crypto is, as Katherine indicated, not monolithic. It can be many different things. And it can be different things to different users. Some people may buy an asset with the idea that it's going to treat it like a collectible. Somebody else may be using it because it is the tool that gives them access to some of the services available on a blockchain network, and others are buying it because they think in the future more people will want it, and that's going to increase the price, which looks more like a traditional Howey type security. And those interests can morph over time, and having a system where no one really knows what an asset is or who regulates it is a very challenging environment for regulators, but also for builders and market participants who just want some idea. The great majority of participants in the crypto markets are trying to do things the right way and just want to have some sense that they have got more than a 3-year administration or 4-year administration window that they're trying to build towards. And some of the guidance we've received so far from the SEC and the new administration is staff level guidance, which can easily change in a new administration. It's not necessarily advancing the ball as much as rulemaking or legislation would, which has a lot more permanence.
So this wasn't a prepared question that we went over last week, but I'm going to ask it anyway.
It's going off book.
Going totally off book. Not really, but because it does come out of sort of this September 5th, 2025, SEC and CFTC joint statement on regulatory harmonization efforts. And I'm not going to ask anybody to sort of prognosticate what we think will come out of that and how successful it will be, because that's like reading tea leaves that are soaked in water that have no ability to be seen. But what I am wondering, because there's a lot of years of expertise in this space on this stage, do we think and are we hopeful that the SEC and the CFTC, barring meaningful, clear legislation that resolves it from a statutory standpoint, will be able to stop their fussing and feuding that they've been at since the 1940s over a myriad of things, right? It's not just crypto. It goes back to securities, futures, et cetera. Do we think they will be able to sort of provide the market and investors with a meaningful set of clear guidance on what is a commodity, what is a future, what is security in the crypto space?
I'll kick us off by just saying, first, I just want to give David a hug right now. I think I was nodding so, affirmatively that I was going to give myself a seizure there. Just, it's nice that we're finally in a place where we have a large swatch of, individuals outside of the market acknowledging that most of crypto is trying to do the right thing, because that's been something I've been harping on for years, and I think that's a huge piece of the puzzle, that there's finally an acknowledgement that it's A, here to stay, and B, that it's filled with legitimate, intelligent, individuals that have integrity. And that's part of the reason why we're seeing these extremely active institutional flows and traditional financial services entities like kind of clawing to get more involved in the space, in addition to potential growth. I will also say, to your question specifically, I hope, because from the industry, again, from the market participant perspective, that's what we've wanted for years. That's what the industry needs to scale to, a fully recognizable, productive asset class. I think it's extremely difficult, however. There's rumors now that, and these are absolutely rumors, ill-informed rumors, that, there's been some dysfunction in confirming the CFTC chair. So, maybe the SEC chair is going to become interim CFTC chair. And I know there's a lot of consternation amongst both the CFTC and the SEC bar, because I think a lot of people outside of the crypto bubble recognize that, as David mentioned, these two regulators have different mandates. One is principles-based, one is rules-based. And although them working together or becoming one and the same might actually work well and functionally for crypto, I don't know how that works for the rest of the market, which still makes up a vast majority of the market.
The Senate Ag Committees and House Ag Committee are never going to let that happen, but for political reasons. But I would just say, to me, from my perspective, I actually think the agencies will work together well on this question of digital assets, because the White House is telling them to work together on this issue, and it's such a high priority. My concern, though, is speed and efficacy of getting to something tangible, solid, and real. Right now, the statements about crypto are very interesting, but they're more talk than action right now, and they're going to be that way for quite some time. And I think for market participants who've been, in many ways, under in crosshairs for years, they're eager to get building, and not having real certainty right now is delaying that and impeding that.
David, Robert,
go ahead, Robert.
I'll just generally agree that I think that the agencies are currently aligned in trying to promote a market-friendly atmosphere right now. But again, to Renato's point, more definition is sought for by the marketplace. And I'll also point out that we at least have some clarity on one thing, and that's stablecoins with the Genius Act. And so that's a positive sort of side note along the way.
Yeah, I was just going to say that from agreeing with Renato, implementation is going to lag. It's just going to take a long time to actually get notice and comment rulemaking through, which will be required whether legislation comes or not. Legislation contemplates the agencies then going by and making regulations that are going to support the kind of legislative principles that are laid out in the laws or the proposals. And just at agencies, having spent a lot of time at the SEC, it takes a long time to put together the ideas, to secure public comments, to do the economic analysis, to corral the votes and get that thing through. Typically a year to 18 months on the conservative side if you're moving relatively quickly, and these are really challenging issues. They're really challenging issues people have been working on for a long time, but the fact that we haven't seen proposed rule text yet, I think talks about how challenging these issues are and how disparate crypto is and what it needs for, depending on where you are in that market. And so having overarching regulations that are going to satisfy a majority of the market participants can be really challenging, and doing that without disrupting what has been a relatively functional securities regulatory scheme for $110 trillion of other markets raises the level of difficulty significantly.
And very briefly, just on the stablecoins point, I think it's a really good one that we have clarity on stablecoins. And for those who aren't familiar, stablecoins are a type of crypto asset where they are pegged to a stable asset. And the most common stablecoin globally is dollar-backed stablecoins. And it's a really important distinction to be made. One of the reasons we got clarity with stablecoins, one of the reasons we passed that legislation is because there was a sense that the United States needed to support dollar-backed stablecoins to continue global dollar dominance. So it was easier to get bipartisan support for stables in particular versus crypto assets, which offer a high degree of volatility that does not exist with stablecoins. There's also a lot of easily consumable use case for things like payments. I think it's a really important distinction. I like to carve them out from this conversation on that basis.
Although I would just say that one thing that I find that people, because you were saying you're doing the New York Times version, people have the sense that crypto is some separate thing out there that you can like regulate away, sue away. It's actually a technology, whether like GPS or Bluetooth or something, that's going to get integrated into all sorts of other products. And banks and other financial services companies are already using stable coins and using tokenized deposits and other things to create value for customers.
So let's talk about that, kind of like in the theme of the New York Times, right? Because the sea change at the SEC has, whether it was driven by or has resulted in a boom in sort of the expansion of crypto offerings available to what I call mom and pop investors, right? You know, it's not just buying, you know, Bitcoin in a platform on your phone anymore. There's a lot more ways to get exposure to crypto. And so let's talk about some of those in the ways that the regulators, both the SEC and the CFTC and other authorities, might be looking at it. Katherine, you want to take the shot at that?
Well, the biggest news lately is generic listing standards, which enable, we're going to see an enormous boom of additional ETF products, crypto asset ETFs. It's much easier to list them. So, you know, your average investor is going to have a lot more choices with crypto exposure via ETFs. You also have a big question mark as to, in the long term or short term, whether the SEC is going to effectuate a Trump executive order allowing people to get crypto exposure in their 401ks. You also have a potential discussion of pension funds being able to purchase spot Bitcoin, but in the interim, you're seeing both a proliferation of crypto public companies like that are IPOing, Bullish, Circle, many on the docket, more to come.
Can I stop you there real quick? So the IPOing of crypto companies.
Yes.
That's an interesting world where like our crypto discussion right here is like only a little bit of the overall discussion, because once you become a public company, as everybody knows, you're subject to the full panoply of the federal securities laws, criminal securities, fraud exposure, et cetera, et cetera. And so anyone have any thoughts on, then we'll get back to some of the other things. Anyone got any thoughts on some of the public company IPOing of crypto companies?
I would say, having worked in this industry for over a decade now, I've always said that crypto has been slowly and steadily becoming part of the mainstream financial system. And that it doesn't happen all at once, and it's often 2 steps forward, 1 step back most of the time. But with this concept of public companies that are fundamentally cryptocurrency-based industry actors, that's one example of how crypto has really entered the mainstream. We talked about stablecoins. That's another way crypto has entered the mainstream. Several public companies now have Bitcoin treasuries, or other crypto treasuries. So that's
That was
another area.
that was my next one.
And
Yeah.
Katherine mentioned the ETFs. And so these are all examples of how crypto has been slowly and steadily joining the mainstream financial system. And I do think that we will continue to see that, but those are four like really solid examples of how it is becoming part of everyday finance.
I'll just say very briefly that this IPOing of crypto companies is a trend. I mean, if you're not following that, if you have a company that is mature enough and you're in the crypto space, you're looking to IPO right now for obvious reasons. This discussion we've had about the sea change makes it a very favorable environment to IPO right now.
And I would say the digital asset treasury companies are a huge theme right now, where basically a bunch of different companies are all launching with some version of what I think MicroStrategy, now Strategy, basically pioneered, which is by intelligently using financing and treasury assets, you can acquire crypto at favorable prices and then use that as a buoy to gather more crypto over time and gather more shareholders over time and increase your market cap, increase your efficiency at buying more crypto. It has worked well for Strategy in the concept of Bitcoin. We've seen other companies launch with varying degrees of success backed by other tokens, and sort of digital asset treasury companies are trying to make SPACs great again.
Yeah, and they also use the underlying crypto assets in the treasury to create yield, because there's a multitude of mechanisms where you can, for example, stake your ether or create yield on using the underlying crypto assets. So that's how they're, enhancing the return to shareholders. However, I think there is a distinct fear in the market that the DATs, or digital asset treasury companies, which basically maintain their underlying basis to avoid becoming an investment committee, but otherwise have a lot of focus on, accumulating crypto, are a bit of a bubble right now.
And going back to kind of the reaction to Operation Choke Point 2.0, or the perception of Operation Choke Point 2.0, President Trump came out with an executive order in August talking about the need to eliminate basically viewpoint discrimination from access to the financial system. Large financial institutions, small financial institutions are all trying to read the tea leaves and figure out, is this actually, okay, we're not supposed to debank someone because we don't like the industry where they're working, or do we actually have to provide access to crypto and a series of crypto products and services in order to be deemed compliant with these expectations, regardless of whether that might necessarily fit within their own preferences or risk profiles, and like what impact that's going to have on how companies expand into crypto and what retail therefore gets exposed into crypto.
Yep.
So we've heard a little bit about recently, there's an SEC statement on it, on tokenized securities. And my question, would love to hear the panel's view, isn't a tokenized security just a security that happens to be a token rather than a stock certificate? Can I just ask the dumb question? Isn't that what it is?
Yes, and
Okay,
that's exactly what Commissioner Pierce said in her guidance. And I think many of the GCs in crypto were happy to see that. It was almost as if she was saying, hello, like tokenized securities are securities, guys. Because there was some confusion in the market. And to be fair, I think some of the confusion stems from the global environment. A lot of other countries have, well-baked crypto regulatory legislation on the books. And in some jurisdictions, if something has been tokenized, it does not maintain the underlying regulatory status, and it becomes it gets slotted into a new crypto category. However, that's not the way the US works, nor should it work, and Commissioner Pierce made absolutely clear that that was the case. We're seeing a lot more tokenization of other non-security assets, everything from real estate to real world assets is the umbrella term. But the new thing is tokenized equities. And there are a lot of legal questions that arise with this whole concept, because a lot of the legal mumbo jumbo underneath has actually not been worked out at all. For example, what happens if there's restructuring, UCC issues, and Robinhood got into a little bit of a hot water in late June when they made a big announcement in Cannes at ETHCC, a big crypto conference, about tokenizing OpenAI stock, and OpenAI said, no, you're not. So obviously there needs to be some precision about exactly what's happening when there's tokenization.
Go ahead.
And I think a lot of the question has to do with distribution, weirdly. Like it comes down to, like one of the major exchanges put forth a rule change proposal recently saying, we're going to offer securities either in traditional certificated forms through DTC or in tokenized forms also through DTC. And you have your choice. We're just going to give you a flag that you signal when you put your order in as to whether you'd rather have it in one or the other. And I think for a lot of people, that isn't really accomplishing the goal of tokenization, which is being able to exchange shares of stock for ETH, for example, or being able to take it out on DeFi and borrow against it and using other kinds of DeFi protocols. And so the question is going to be, is this a distinction without a difference, where for most consumers it might be tokenized, but the experience and liquidity are going to be exactly the same? Or is this a completely different way that people are going to be able to exchange assets?
Questions coming to you to clarify. DeFi protocols for the audience.
Sorry, I slip into jargon constantly.
I was the GC of a DeFi protocol. That was actually my first GC. Decentralized finance, which effectively means they use something called smart contracts type of technology, which are algorithms that automatically execute if certain terms are met. So the whole concept of DeFi is we're going to take traditional financial services and replace intermediaries with technology. And protocol is the terminology used for the technology itself.
Thank you. So Robert, I'm coming to you. Before we finish up with some final thoughts on enforcement, I want to ask you one question, which is, Katherine mentioned the tokenization of non-security assets, like real estate is one thing she said. And I'm not saying the tokenization of real estate makes that token a security, but wouldn't it at least give rise to an analysis about whether you're essentially creating a REIT or some other kind of security whose underlying asset or which underlying asset is real estate?
So as Katherine mentioned, the legal issues underpinning all this stuff can get quite complex. I think what's more interesting is to think about the vision that Chair Atkins laid out in his recent speech, where he talks about what he called the Everything app. And the idea there is that the vision, if rules can be created to help support this, is that someone can one day have an application where they can trade crypto, they can trade stablecoins, US dollars, tokenized securities, tokenized real world assets, all in one place. And I don't know if we'll get there anytime soon, but I do think that looking at that as a vision for what the right type of rules will support is a really compelling concept, and I think could really, again, be another instance where the traditional financial world merges more and more with the emerging Web3 and crypto space.
Can I just say one thing, is everything app, I mean, I think there's a race right now and a competition of sorts between the SEC and CFTC. There's, will the ATS or the DCM be the everything in, place where things are traded? And, when you talk, if we're, Katherine and I have been on plenty of digital asset events recently, and that is something a lot of people are talking about right now, and there's regulatory shopping of sorts that's going on there.
So something people are also talking a lot about is state enforcement. So maybe let's talk about that for a few minutes.
Sure, I'll just say, I mean, that is incredibly active right now. State attorneys general really believe that they need to fill the gap, regulatory, enforcement gap that there is right now based on a less enforcement coming at the federal level. So they're enforcing on a variety of fronts. But certainly in this space in particular, and not just this space, but I would say other related spaces like fintech and so forth. I mean, depending on how we're defining what our panel's talking about. But there's been a lot of enforcement, and of course we're seeing state regulatory regimes grow as well. So, New York has a BIT license, and Louisiana, California has a BIT license that's going to be coming online in the middle of next year. And here in Illinois, we now have a BIT license that will be coming online in 2027. So more and more states are getting into that game as well, and really federal legislation is going to determine the extent of preemption and how much the states are going to have a role in continuing to enforce.
Yeah, and as Renato knows, and because he was very helpful in the advocacy, I'm on the board of the Illinois Blockchain Association. We fought really hard the recent Illinois law that was passed. It's called DACPA. It effectively, creates a state licensing regime for digital asset businesses. And what we fought for was, again, not regulation. We're not opposed to regulation, but the original language of the law was extraordinarily broad. So what I see most troubling about the state's posture is they perceive a gap on the federal level, both in legislation but also enforcement. So they're moving, and we're creating this complete and utter patchwork of laws. It's like the old school money transmitter regime, but without the universal MTL law. And I was previously chief legal officer of a DCM and a DCO, a CFTC registered crypto derivatives, and also a crypto spot market. So we had to deal with 50 states. It was a nightmare just with the MTL. So if you're throwing MTLs and various state bit licenses at us, you're also suffocating businesses with these enormous costs that are, again, unique to this asset class.
And I will say, at the SEC in enforcement, we worked very closely with the states. And I think overall, a lot of the state enforcement practices were fairly closely aligned with the SEC practices of the last administration. I think with the new administration, we're seeing more of a divergence, where some of the states are continuing to kind of lead the charge on enforcement, and others are starting to take a bit of a step back and say, let's see what guidance we get from the SEC, from the CFTC, from legislation, and we're going to move a little more slowly, a little more judiciously.
Yes, I think there's more to be seen based on sort of as these state crypto laws that are, if the Illinois one, for example, become more mature, what the state attorney generals and the securities commissioners do from an enforcement standpoint. But so let's finish up here by saying, now we've been talking a lot about what happened in last year and what's going on now. 1 year from now, well, you're going to be on this in 2 years, because every 2 years. On this panel, right?
Well, I was on last year's too.
Oh, you were too?
Yeah.
Okay, so maybe next year.
But it was already looking, I was cautiously optimistic given the election.
So let's, in a year from now, what do you say the biggest changes or the biggest surprises?
I guess we're going down the line. So I don't think we'll see a big change in a year. I think the question is, where are we going to be in 3 years? Because one of the things as a GC that I am hyper cautious of is I'm not taking advantage of this regulatory environment, actually the opposite. And all of the crypto GCs, we talk to each other and we're all kind of banging our heads against the wall, because what we're getting from our companies is, well, why can't we do this? That project's doing this. Why can't we do this? Or, oh, the regulators are hands off. And that's not the posture of a responsible organization to begin with, but also I am strategizing for the long term and for the myriad of scenarios that we're going to face if there's a different administration, if there's legislation. So there's a high degree of uncertainty. I think in a year, we're going to have a lot more activity in this space, a lot more institutional growth, a lot more products, both from the CFTC and from the SEC perspective, a lot more flows, like share money involved. And that's ultimately a good thing, but I also hope to see, frankly, more enforcement action with the, levied against the true kind of bad guys in the space.
Yeah, I think we're still going to be in a accumulation mode, where I think the more entrants into markets, those entrants are going to be bigger. I think something will likely break, whether it's next year or 2 years, but that's just how markets work. There will be something that blows up and that causes some consternation.
Yeah.
I think resource constraints are going to prove out to be a real significant issue. CFTC, prior to Doge and other things, and I think 175 total enforcement staff, but they're being proposed to take on a lot more responsibilities under legislation or rulemaking. SEC headcount is down, even though they're fantastic. It's going to be challenging. So I think that is going to be an impact and impediment to some enforcement.
I think we're going to see a very significant breakdown in the distinction between TradFi and DeFi. I think you're going to see, there's this sense, okay, we have all, we were talking a minute ago about all these crypto companies IPOing, and there's this sense that certain companies are, quote, crypto companies, and then you have all these traditional financial services companies. They're trying desperately to catch up. Some of them are at light speed, doing all sorts of interesting things with blockchain. And of course, as Robert mentioned, Genius Act is going to be putting trillions of dollars into blockchain. So I just think that we're going to rapidly see this whole question become less of a hot button issue and more of a mainstream issue of how do we deal with some new technology that everybody's participating.
And Robert.
I think a year from now, we will see continued market growth, so market growing beyond where we're at now. I think that we will have some meaningful degree of either guidance or proposed or interim rulemaking from the SEC that maybe doesn't solve all of the problems, but maybe takes a piecemeal approach and solves some of the problems that the market is looking for answers on. And what I hope we don't see is a market shock event, which does happen periodically in this industry, and hopefully that won't happen between now and a year from now, and that would put the industry on a continued path to grow and to continue to integrate with the traditional financial system.
Market shocks can change enforcement trajectories. It's interesting that nobody said there will be like an Elliot Spitzer moment from like 2004. We all remember that I'm talking about when he steps in on the mutual fund trading, right? Which literally altered the 2 years of SEC enforcement and how they were dealing with those cases. Interesting, nobody saw somebody jumping in and filling that role. So, well, we're out of time, guys. Thank you very much.
Nice job. Thank you. Thank you very much.